Thank you. The first case that will be reviewed this morning is Landa Danielle Postel. And you would prefer to have these placed in that, all right? This is an arrest affidavit from yesterday, Sunday, November the 17th, from 1669 East Silver Star Road. The charge is felony battery. It is alleged that great bodily harm occurred. The bond has been set at $2,500. The public defender is appointed to represent you in Division 11. You'll want to stay in touch with your attorney. When you bond out, your attorney will need to reach you to keep you advised of each and every hearing, because that bond that is posted is to assure your appearance at each and every hearing that's scheduled until this case is resolved. This is Damaris Santiago.
Yes.
The matter that's before me this morning is a capias. A capias tells me that an information has already been filed by the state attorney's office, and so this is subsequent to a filing of an information. It shows that in Division 20, this capias was issued October the 31st of 2019 for failure to appear for pretrial conference on October the 29th. Release was revoked by that judge and ordered that you be held on a no bond until you see that judge. That's the judge in Division 20. The two charges originally, possession of cocaine and possession of drug paraphernalia. A complication that will be reviewed by that judge is that you were out on bond on a charge, a separate charge, case number 2019 CF 14633AO, the charge of aggravated assault with a deadly weapon in Division 10. And you have the attorney, Shantae Perry, in that charge. It had a bond of $1,500. And I am to review that today. What is the state's position with regard to the separate charge? That charge right now, I believe, is actually holding Ms. Santiago on a no bond until I take action one way or the other concerning that prior matter. She's already on no bond on the failure to appear as well.
Your Honor, just to double check, the other charge is 19 CF 14663.
Yes.
May the state have one moment?
All right.
It's 14633.
633.
The date of the arrest on that case was October the 19th, and it indicates she bonded the following day.
Your Honor, as of 10/29/2019, the state received additional information. It appears the case is still open. It's an aggravated assault with a deadly weapon, and she has two failures to appear. The state's position is that she is not eligible to be ROR'd.
It appears to me that I am to take the following action, and I also note it conveniently for all parties the same judge is assigned to both cases. So the judge in Division 20 will see Ms. Santiago with regard to both matters. I am to, on the prior case, aggravated assault with a deadly weapon, 2019 CF 14633, I am to revoke that $1,500 bond and hold her without bond until she sees, and I stand corrected. I am incorrect on that, the same judge. That prior case is Division 10. Ms. Santiago's next step in Division 10 is to see the judge in that division so that judge can decide whether the judge wishes to give new bond. But my obligation as a first appearance judge is to note that because you failed to appear according to the judge in Division 20 on October the 29th, which was 9 days after the release on the prior case. So I do revoke the bond, and you're held without bond till you see the judge in Division 10. So it's no bond in each of those two. However, you can get a hearing in front of each judge, and each judge may give you new conditions of release. My decision has only to do between now and when you see the judge assigned to the case. All right. And you have the public defender on the new chart, on the new matter. This is Ray Lamar. You are being held on a charge of trespass after warning from yesterday at 455 North Garland Avenue, and I believe that's the address of a parking lot in the middle of downtown. The bond is listed at $500. I also see that you had been previously released on a charge of trespass after warning. That release was November the 5th, after having been arrested on October the 14th. So it indicates that you had been in jail for 3 weeks before you were released on that prior trespass on property after warning assigned to Division 83. This is a case where it might be appropriate to hear from the state as to whether there's an offer made to resolve either or both of these two charges. Actually, it would be on the new charge only. The prior case is already assigned to a division, so only that judge can make that decision. But on the new case, is there an offer from the state to resolve the new charge of trespass after warning?
Your Honor, yes, at this time, the state may offer credit time served for the charge of trespass.
All right.
You said credit time served?
Yes.
So I want you, I do appoint the public defender to represent you on this new charge of trespass after warning. I want you to talk with your attorney as to whether you feel it's better for you to enter a plea knowing it will be time served. And I intend to take no action on that prior trespassing. Or if you feel it's best for you not to resolve that case, you must be able to post a bond of $500.
Your Honor, he'll accept the offer, enter a plea of no contest.
All right. And I see that the location indicated is the Lynx bus station. So state your full legal name and your date of birth.
Right, Raymond, Beatrice Ford.
All right. The charge that's before me today is from yesterday at the Lynx bus station, 455 North Garland. How do you plead to that charge?
Guilty.
And did you have an opportunity to read and understand your plea form that you signed?
Yes, sir.
Okay. Do you have any questions you want to ask me about this charge or the facts of the case, the plea that you're entering, or the proposed sentence? Okay. Are you willing to stay away from the Lynx bus station knowing that they're going to arrest you each and every time they see you coming? You must find some other location.
Yes, sir.
All right. I'll accept the plea at this time. Are you satisfied with your attorney, the public defender, or do you, and also, did you have enough time to decide what's best for you?
Yes, sir.
All right. That plea is accepted. It's an adjudication, time served, so it's 2 days, credit for 2 days served. Your court costs will go into a civil judgment. I don't believe you have the ability to pay the court costs at this time, but I am not allowed as a judge to waive the costs. The costs are still payable, and you will receive a document that indicates how much you owe for the court costs of this case. I order that you not return to that Lynx bus station as a condition of this, as a part of this sentence. You're not to return during the next 177 days. And I release the hold on that prior case. Okay, is this Livingston Dodard?
He refused, Your Honor.
All right. Judge, it appears that Judge Munyon was the emergency duty judge and was here either yesterday or the day before, and that was also a refusal, and she rescheduled it for today. And so this will be the last refusal since that has occurred. It is indicated here that he was out on bond on a prior case, so he's being held without bond. All right. The step I will take is to take no action on that prior case. He's still being held without bond. What I will do, because he has refused twice and he cannot get out until he has a first appearance, at this time I will appoint the public defender to represent Mr. Livingston Dodard on this case, for them to find out why he is unwilling to come see the judge since he's being held without bond until he sees the judge. Because of the prior case, there's a hold. He has a bond of $1,200 on the new charges.
So you revoked, Your Honor, you revoked the bond?
I have not taken any action on
Okay.
that because I believe I have to see him
Okay, Your Honor.
to make that decision. So he needs to hear from his public defender that I've just appointed that he's holding himself in jail.
Okay.
All right. But he will not be reset until he requests the first appearance through his public defender. Perhaps the best way to do that is I will reschedule his first appearance for Wednesday. We'll see what happens between now and Wednesday. And all that will happen if he never does want to come is I will be forced to revoke the bond on the prior case, and he's still held without bond, so. All right. Henry Allen Raymond.
Yes, sir. How you doing, Your Honor?
Good morning. This is a reset. Judge Munyon determined that you were not able to be seen, and so I am holding this first appearance today. And there are 3 charges from November the 15th. The arrest took place at Cayley and South Orange Blossom Trail. In the parking lot of a gasoline station. Count 1 is a felony, possession of cocaine. Count 2, possession of meth. Count 3, possession of drug paraphernalia, misdemeanor. The total bond is $1,250. The case is assigned to Division 20, which is Judge John Marshall Kest. The public defender is appointed to represent you on these charges. There's probable cause to hold you, and your bond is $1,250. I order that you not return to that location of the arrest, which is the gasoline station at West Cayley and South Orange Blossom Trail, while the case is pending. Stay in touch with your attorney if you bond out so that you'll know when to go to court for your next hearing in front of Judge Kest.
Fine, that's not. My name on it.
Marilyn Zubler.
Yes.
This first appearance was reset from the weekend. It is a charge of trespass on property after warning, which is a misdemeanor, first-degree misdemeanor. The public defender is appointed to represent you. The charge is from 455 North Garland Avenue, which is the Lynx bus station. So you do have an attorney. There may be an offer from the State Attorney's Office to resolve this case today at first appearances.
That's correct, Your Honor. The state will be offering credit time served, court costs, and adjudication of guilty.
Okay? You'll want to talk with your public defender now as to what's best for you. You can either bond out or you can enter a plea knowing it will be time served. You should not enter a plea if you're on probation, for example, or if you feel you're not guilty and you want to bond out. But if you do want to resolve the case and your attorney agrees, then that can be done today. You would be released later on today.
I'd like to resolve it, and I'd like to plead guilty, right? Oh,
Well, if you and your attorney both feel that that's appropriate,
yes.
She would like to accept the offer, enter a plea of no contest.
all right. You can enter a plea of no contest, and it will operate the same as a plea of guilty, but you are not admitting any particular facts in the case. What is your full legal name? What's your name
Marilyn Giordano Zubler,
and your date of birth?
10/17/1963.
All right. Is there anything that keeps you from making a decision as to what's best for you today? For example, do you feel that you're under the influence of alcohol or anything else?
No.
Have you had enough time to talk with your attorney about your options today?
Yes.
How do you plead to the charge of trespass after warning at the Lynx Bus Station, 455 North Garland Avenue from day before yesterday?
No contest.
All right. Did you read and understand your plea form?
Yes.
Any questions you want to ask me about this case?
No.
Are you willing to stay away from the Lynx Bus Station?
Yes. Sorry.
Well, you know now
Yes.
that if they see you, they will call the police and you'll be right back here. And sometimes I see people over and over again because they don't remember. So that's something you're gonna have to remember. Go somewhere else other than that location.
Okay.
Are you satisfied with your attorney?
Yes.
I'll accept the plea at this time. You're adjudicated guilty of the charge, state charge of trespass after property after warning, a first-degree misdemeanor. The sentence is time served. You were arrested on the 16th, and today is the 18th, so it's 3 days, credit for 3 days served. No return to that location, and that no return is during the next 360 days on this. And I am presuming you received a trespass warning there, which may be a permanent one, but as far as this case is concerned, it's during the next 360 days. You do have court costs, and you will have, what's the amount of time they ordinarily give? Okay. You will also have 360 days to pay the court cost of the case. You'll be released later on today. This is Scott Matlock.
Yes.
This is an arrest affidavit for a misdemeanor charge. It's a first-degree misdemeanor charge. The title of the charge is possession of drug paraphernalia, and it's from yesterday at 2501 General Rees Avenue. And that would be in the general vicinity of Glen Ridge Middle School. The bond is $500. The case has now been assigned a case number. It's 19MM9315-0. It is a case where there may, and I do appoint the public defender to represent you, there is an opportunity for the state attorney to make an offer at first appearances if this is appropriate.
Your Honor, at this time, the state does not have an offer due to the defendant's history, so there will be no offer conveyed.
All right. You can now bond out on a $500 bond. If you are not able to post a $500 bond, but you are seeking to secure your release, you must apply to the judge assigned to this case. It will go to a particular division. Or you can have your public defender file a motion for a reduction of bond or release on ROR based upon your ability to pay and the judge's analysis of whether you will appear without having to post bond. But today, the appropriate bond is $500. This is State of Florida, it's Kaz Gregory Stepp, S-T-E-P-P. This is a charge of trespass on property after warning. It comes from 2,000 Fowler Grove Boulevard, and that would be in the city of Winter Garden. The bond is $500, and the public defender is appointed to represent you in this case. Is this a case in which an offer is being made by the state attorney's office at first appearances?
Not at this time, Your Honor, due to the defendant's history.
All right. Mr. Stepp, you can now post a $500 bond, but there is an additional condition on your release, and that is you will not be allowed to go within 500 feet of the Advent Health at 2,000 Fowler Grove Boulevard while this case is pending. So if there is some situation where you are in need of the services, you will need to go to some other location other than that particular one because you've been trespassed there. You do have the public defender, and you can now post a $500 bond. Kevin Benjamin. This is an arrest affidavit charging possession of heroin with a weapon, possession of cocaine, and possession of a weapon, concealed weapon or firearm by a convicted felon. The first charge has a no bond status listed. Count 2 having a bond of $1,000 and count 3 having a bond of $5,000. The case has been assigned to Division 22, and I've appointed the public defender to represent you. It appears to me that count 1 that has the no bond status, I am to set the conditions of release at first appearances. What is the state's position concerning what would be the appropriate conditions? I don't believe it's a life felony.
That's correct, Your Honor. We leave it to Your Honor's discretion as to what to set the bond, since it is not a punishable by life.
All right. I believe that the following is appropriate for the charges as shown by the, I have to use what is alleged in the affidavit as my basis, and your prior record, of which I have a rough description. It indicates the following would be appropriate. Count 1 will be a bond of $150. Count 2 is a bond of $150.
And Your Honor,
And count 3 is a bond of $5,000 as already charged.
Your Honor, in regards to the possession of cocaine charge, I have a probable cause challenge.
Yes, you may be heard.
Within the affidavit, it does not state that coke was found in the defendant's possession.
It has a very sparse but long paragraph, one single paragraph concerning the allegations of the arrest that took place on November the 17th, yesterday, at South Avalon Park Boulevard and Moultrie Point Road. What is the state's position concerning the lack of specific allegations concerning count 2?
Your Honor, the state is aware that this is missing. The state at this time asks for 24 hours to contact the officer to get additional information about the arrest so that probable cause can be proved.
And Your Honor, defense objects to the state's request. There's no extraordinary circumstances that requires them to get additional time for probable cause.
All right. And looking at the affidavit, as I indicated, it is much more concise than I'm used to seeing for such a set of 3 charges that I have before me. And it does have, simply at the end, guilty of possession of cocaine, as being a prior conviction and others like that. And I do not see any indication in the body of the narrative concerning cocaine. But clearly, the charge shows up in count 2, and the state is given 24 hours to produce either an amended arrest affidavit or a supplement that would indicate, that would convince me tomorrow morning that Mr. Benjamin actually, that there's probable cause that he was also in possession of cocaine. If that is not accomplished, then there will only be the $5,000 bond on count 3 and the $150 bond on count 1. If, in the meantime, Mr. Benjamin does bond out, and he can choose to go ahead and bond out immediately on $5,300, there would be a condition of not to be in possession of a firearm, not to be in possession of any substance prohibited by law while the case is pending. But the bond right now is $5,300, subject to a hearing tomorrow on probable cause on count 2.
He does have a probation hold. Probation hold.
All right, there's a hold on probation, so it sounds as if we will see you tomorrow morning on that issue of count 2. Jose Cabasa.
Yes, Your Honor.
This is an arrest affidavit from yesterday at 3617 Columbia Street. Count 1 is possession of alprazolam. Count 2, possession of oxycodone. Count 3, possession of methamphetamine. Those are 3 felony charges. But based upon our local rule, count 1 will be a bond of $1,000, count 2 will be a bond of $150, and count 3 will be a bond of $150, for a total of $1,300. There's probable cause to hold you in Division 15, and I've appointed the public defender to represent you. You can now bond out. You'll also have a condition of not to be in possession of any substance prohibited by law, plus $1,300 bond.
He does qualify for pretrial release.
Based upon the allegations contained in the narrative and the charges, I will require that Mr. Cabasa post cash bond as listed, even though he does qualify.
I don't.
Savandasi.
Martinez Alexander.
Okay, Dasi is interpreter.
Dasi's in the hospital, Your Honor.
All right. I'll make an announcement concerning Mr. Dasi. Okay. He is being held on the charge of attempted first-degree murder with a firearm, innocent no bond status, with a co-defendant, Miquis Humphrey, and it's from yesterday at 5197 Lynette Street. There has not been an opportunity for him to apply for a public defender. We will simply reschedule this for tomorrow, and we'll continue to reschedule it until he can be seen for review for public defender. But he is being held without bond, and I find that he is being held without bond until, unless and until there's a hearing before me at a later date, or before the first appearance judge if it takes more than a week. Alexander Cardenas.
Yes, sir.
This is a charge of petty theft, but it is charged as a felony because it is alleged that there are 2 prior convictions and a 3rd conviction in the state of Florida of petty theft, even though each individual case may have involved a small amount or small inexpensive items, or the fact that it's the 3rd one can be charged as a felony. And if there is a conviction in the case, it can be sentenced as a felony charge. And that's what you face today. It comes from 3060 West Sand Lake Road from yesterday. The bond is $1,000. The public defender is appointed to represent you in Division 16. The location is the Walmart at 8101 South John Young Parkway. And so if you do bond out on a $1,000 bond, there will be a requirement of no return to the Walmart at 8101 South John Young Parkway. Is this a case, this being a felony, the case cannot be resolved at first appearances. And you need to stay in touch with your attorney so that you know when your next hearing is in front of the judge in Division 16. Anthony Fabiani III.
Yes, Your Honor, good morning.
This is an arrest affidavit from yesterday. 6300 Spanish Oak Drive was the location of the arrest. The charge is armed burglary. It is a possible first degree, or it's a possible life felony. It's a no bond status today. The location alleged of the event, this is subject to the case, is also 6300 Spanish Oak Drive. There's a second arrest affidavit. It has 2 charges. Count 1, aggravated assault with a weapon, bond $2,500, and count 2, battery, which is commonly termed simple battery, but it's a first-degree misdemeanor. It has a bond of $100 when it is combined with a felony. $2,600 then is the total bond for that second case. The first case is in Division 19, the second case is in Division 20, and the case number for the second case is now 19 CF 15943. I do not have an application for criminal interest status from you. You have not signed an affidavit seeking the public defender. Does that mean that you are planning to hire a private attorney concerning these 3 charges?
Yes, Your Honor.
All right. Advise your private attorney as soon as possible to contact the judge in Division 19, because until you see that judge, you're held without bond.
I will not be released I don't have a bond today, so, Your Honor.
You do not have a bond today until there's a bond hearing, a motion to set bond, because the charge of armed burglary is a possible life felony. I will do this. I'll ask the state, is in fact the state asking that he be held without bond?
That's correct, Your Honor. Due to the nature of the offense and for the safety of the witnesses, the victim, and the community, we ask that the defendant be held at no bond.
Your Honor, I have no intention of going anywhere near the defendant.
And that may be. The judge assigned to this case has the ability, has the discretion to set bond after a motion to set bond. The issue will be at that time the strength of the state's case. The state attorney will have the responsibility to prove to the judge that the proof is evident, the presumption is great that you committed the crime. Even if they do that, the judge still has the discretion to set bond if it's appropriate, if that judge feels it's appropriate. But if the state attorney is not able to prove that, that judge must give you bond. There's no discretion if they cannot prove that. But today, this is simply a first appearance, and I do find it is a possible life felony, and I must hold you without bond till you see the judge in Division 19. That's why I'm advising you to contact your private attorney immediately.
Other question, Your Honor? If I was to seek public counsel from a public defender, would that entitle me to eligibility of a bond?
I would not, based upon the allegations, again, the judge that's assigned to the case, Division 19, is the judge that'll have to hold that hearing.
Thank you, Your Honor.
The next case is Chance LeGrand Heavener. This is a warrant arrest affidavit. It is a capias. That means to me that an information has been filed against you. It indicates that the judge in Division 84 on a petty theft charge, which is a misdemeanor, found that you failed to appear for arraignment, and so you were to be arrested, but you were to be released ROR. Therefore, you will be allowed to be released on that case, on that case, which is case number 2019 MM761AW. The W on that AW means west. It was an event that occurred west of John Young Parkway. On that case, there is a second matter. It is a warrant arrest affidavit in Division 20, Circuit Court. These are felony charges: possession of heroin, possession of drug paraphernalia. And it is a capias. It indicates failure to appear for pretrial conference on September the 24th, 2019. Your release was revoked by the judge in Division 20, and you're held on no bond. So you will need to see that judge in Division 20 in order to secure your release, even though you're not being held on that first case. I appoint the public defender to represent you today in Division 20 and Division 84.
And Your Honor, Mr. Heavener, he stated that he was incarcerated at this time, and he also states that he has documents to prove it.
And that's what he will need to do in front of the judge in Division 20.
Okay.
This is State of Florida. It's Mequis Humphrey. This is a charge of attempted first-degree murder with a firearm. It is a no-bond case. It indicates a co-defendant is Savon Dassey, And earlier, I was advised that he is in the hospital, so he has not had a first appearance yet. The case is assigned to Division 12, and I find probable cause based upon the narrative alleging facts concerning an incident yesterday, November the 17th, at 5197 Lynette Street. You have filed an application for criminal status, but you have not qualified and do not qualify based upon the analysis by the clerk of the court. I notice that the notice of invocation of constitutional rights has been filed in this case, but you do not qualify for the public defender, so your obligation is as follows. If you feel that you cannot actually afford an attorney based upon practical reasons, and there are many situations where that occurs, you must attempt first to find or have family members or friends attempt to hire a private attorney, so that when you have your next hearing in front of the judge in Division 12, you can show that your attempts to hire a private attorney were unsuccessful due to what those attorneys required from you. For example, let's say attorney number one says you must pay $5,000 up front, and you can testify you clearly do not have that ability, nor do you have friends or family that can do that, or whatever it may be. And attorney number two, same thing, whatever it is, that judge can ultimately appoint the public defender, even though you do not right now qualify, because as a practical matter, it's clear you're not able to hire a private attorney, but that's the process you will have to go through. Right now, you're held without bond due to the allegations, and it's in Division 12 to get own attorney. One condition of this case is not to have any contact with anyone that is named or shown to be a witness, victim, co-defendant, while the case is pending. Alexander Lopez.
Good morning, sir.
Morning. There are two affidavits here, I believe. The first is grand theft, third degree of a motor vehicle with a bond of $1,000. Count two, possession of heroin, bond of $1,000. The local rule concerning bonds indicate that one of those two cases will become a bond of $150, while the other remains at $1,000. I'm appointing the public defender to represent you in Division 12. Which of the two charges in the first affidavit, and you can talk with your attorney about that, which of those two do you wish to have as the bond of $1,000 and the other be $150? It doesn't matter to the court, it's up to you. Either way, the total bond will be $1,150 from that affidavit.
Your Honor, we have no position.
All right. The order of these had grand theft first, so that'll be the bond of $1,000. The second being possession of heroin, it will now be a bond of $150, so the total is $1,150. The second affidavit is for a misdemeanor. That charge, driving while license suspended or revoked knowingly, bond is $500 on that case.
Sir? Sorry.
And the case number is 19 CT 1363, and it's assigned to Division A. It's a misdemeanor charge. You can now bond out on that case, and there would be a condition of not to drive while the case is pending unless you can show your license has been reinstated.
And Your Honor, just to clarify, it was $1,000 bond, $150 bond, and then a $500 bond?
Correct. This is James Robert Nagany. There are 3 charges listed here from yesterday. 3343 Daniels Road, which is the address of a Target store. There are 3 charges from yesterday from the Target store at 3343 Daniels Road. Count 1 is resisting a merchant. Count 2, petty theft. Count 3, using an anti-shoplifting or inventory control device. That 3rd charge is a felony charge, so it has the bond of $1,000. The bonds for count 1 and 2 should be now a bond of $100 each. Your total bond is $1,200. The public defender is appointed to represent you in Division 14, and I order that you not return to the Target store at 3343 Daniels Road while this case is pending. You can now bond out. Paul Sanchez Maldonado.
Yes.
This is a uniform traffic citation that has turned into an arrest affidavit because the charge is a felony charge. It is driving while license suspended or revoked, but it is a 3rd offense. And this is the type of charge in which each conviction can be a more serious offense. The first one is a 2nd-degree misdemeanor. A 2nd offense is a 1st-degree misdemeanor. And a 3rd offense can be charged as a felony. In this particular case, it has been charged as a felony. The bond is $2,500, and I would add an additional condition that's appropriate, and that is not to drive until your license is reinstated while the case is pending. This case comes from North Goldenrod Road from yesterday. I appoint the public defender to represent you in Division 17. And that, I believe that is Judge Kevin White. All right. So you can now bond out, and you have the public defender. Stay in touch with your attorney so you know when your next hearing is. William Bonilla Cruz.
Good morning.
Good morning. This is an arrest affidavit from yesterday. These are misdemeanor charges. Actually, they are city ordinance violations from 648 West Washington Street. Count 1 is alcohol being possessed in public. Count 2 just says state misdemeanor. So in looking at the facts alleged, it is having possession of a drug paraphernalia, which if it was a state charge would be a 1st-degree misdemeanor, but it's charged as a city ordinance violation of the city of Orlando. So each of those cases has a maximum sentence that could be imposed of 60 days in jail and or $500 fine. There are 2 of those. Right now, count 1 has a bond of $250, and the 2nd charge is a bond of $100 for a total of $350. I've appointed the public defender to represent you, and the case number is 19MO1850-0. The state attorneys that are present here in the courtroom on behalf of the city of Orlando sometimes are able to make an offer to resolve the case at first appearances on behalf of the city.
That's correct, Your Honor. At this time, the state would like to offer credit time served.
All right. I want you to talk with your attorney to see whether it's better for you to enter a plea to these charges. The sentence will be time served, court costs, with a year to pay the cost. And If you feel that's not appropriate, you will be able to bond out on a $350 bond.
And state, is that adjudication of guilt?
Yes.
Your Honor, he'd like to enter a plea of no contest.
Thank you. What is your full legal name
William Bonilla Cruz,
and your date of birth?
092791.
All right. Count one is a charge of being in possession of alcohol in public, a city ordinance violation. How do you plead?
Guilty.
Count two is a city ordinance that simply incorporates state misdemeanor charges. It's the equivalent of a paraphernalia charge, but a city ordinance violation. How do you plead?
Guilty.
All right. Did you have enough time to read and understand your plea form? You'll need to say yes or no so
Oh,
the
yes.
tape picks up
Sorry
your
about
answer.
Yes.
Any questions you have concerning these two charges, the facts of the case, the plea that you enter, or the proposed sentence?
No.
I note that you've been an adult for about 10 years, and you have an extensive record. So do you understand that you're getting a pretty good result here, considering the charges and your prior record? And you need to make sure that you avoid this type of thing in the future for your own good. I mean, these are kind of minor things, but you may get to the point where you get stuck in here for quite a while due to your prior record. All right? Are you satisfied with your attorney?
Yes, sir.
I accept the plea at this time, and I adjudicate you guilty on each of those two charges, and the sentence is time served, and that is, it's 2 days on each one, running concurrently, as at the same time you'll be released later on today. You must pay the court costs, which is one court cost for the case number, and that will be payable within 360 days from today.
Thank you.
Jeffrey Edward Bayham. This is an arrest affidavit from yesterday. Count one, trespass on property after warning. Count two, soliciting without a permit. Total bond $600. It indicates it's 8910 South Orange Blossom Trail. And so that would be south of Sand Lake Road. It indicates it's in the area of West Land Street Road, which is the next major street, I believe, south of Sand Lake, or in the vicinity of the Turnpike. And it indicates it's the trespassing charge comes from a 7-Eleven, 8910 South Orange Blossom Trail. And then that second charge is soliciting without a permit. So they call the sheriff due to their customers being interfered with, generally is what happens. I appoint the public defender to represent you in the case, and there may be an opportunity to resolve the case today. Is the state making an offer on these cases today?
No, Your Honor, the state will not be making an offer today.
All right. You do have the public defender, and you can bond out, and your bond is $600, and no return to the 7-Eleven at 8910 South Orange Blossom Trail while the case is pending. This is not, the case I have in front of me is not the person before me. This is, the case I next have is Jacob Craner.
Yes, sir, he's mental health.
All right, rescheduled for tomorrow to see if he can be seen tomorrow. This is Ashley Nicole DeLauder. Are you Ms. DeLauder? All right. This is, a charge of possession of drug paraphernalia from yesterday at 4252 South Orange Western Trail. The public defender is appointed to represent you. The bond is $500, and that's a Chevron station. That's, that would be 3 blocks south of the light at 39th on the trail. This is a case where you have substantial history, but the state may have an offer to resolve this case at first appearances.
Your Honor, may the state have one moment?
All right?
Your Honor, the state has no offer at this time.
All right. You can now bond out on a bond of $500, no return to that Chevron at 4252 South Orange Boston Trail, not to go within 500 feet of that location. You have the public defender, and I also add a second condition of not to be in possession of any substance prohibited by law or paraphernalia while the case is pending. Sheena Vontra Fisher. This is a charge of trespass after warning. It is a first-degree misdemeanor. It is from yesterday at 625 Indiana Street. The case is complicated by the fact that Ms. Fisher had been released on November the 5th or shortly thereafter on a charge of, a felony charge of petty theft with 2 prior convictions assigned to Division 11 and the public defender. I appoint the public defender to represent Ms. Fisher on the new charge, misdemeanor trespass on property after warning. What is the state's position concerning the prior case for which she had been released, the felony charge?
Your Honor, may the state have a moment to look at the prior
All right.
case?
while that's being done, the arrest affidavit indicates your residence is 4147 Olivia Street. I don't know if there's really an Olivia. I'm thinking it might be.
They switched my address. I have that 625 address and also that 4645. That's been my residence since I've been out for a year. My boyfriend, I don't know, what's his problem?
Don't go
I'm
into,
sorry.
don't go into any
I'm
more than
sorry.
that. I was just, I wanted to, what I was really asking, is that in fact, is that the correct name of the street?
Yes,
being
that's the
referred to?
name, but not the numbers. It's
Oh,
46.
okay. It is Olivia?
Yes, sir.
Okay, all right. So just make sure that your attorney knows exactly what your residence address is.
They know I just got out Friday.
All right.
Your Honor, I apologize. Just to confirm, do you have a case number for her previous?
Yes, that prior case is 2019 CF 11619 AO, Division 11. The rest was November the 5th, represented by the public defender on a petty theft with 2 priors. Oh, 2? Oh, there's also, as it's been pointed out to me, there's also a second release from June the 21st, case number 2019 CF 6666, Division 14, charges possession of controlled substance and possession of drug paraphernalia, ROR, with a return date of December the 12th. Public defender representing her on those charges.
Your Honor, in reference to 19 CF 11619, it is still, it looks like it's pending and was recently transferred divisions. So that is currently pending as of our records.
Which case is a transfer of divisions?
Both of them.
That case is, I apologize, Your Honor. That is the petite theft, 2 prior convictions. In our records, it states that it has been, it's been requested for an administrative transfer.
All right, so in all likelihood, it's been determined that it will be charged only as a misdemeanor petty theft, and it has gone to county court. That ordinarily is what happens with an administrative transfer for a petty theft, from felony down to misdemeanor, but it's still an active case. I might suggest that I believe what's appropriate in this case, looking at all these charges, is that she has been released on the prior cases without having to post bond. I believe because of this new case, I should set the bond as would be set. I should set a bond on these prior cases due to the fact that she now has a new charge. In other words, I'm gonna revoke her release but set a new bond.
Yes, Your Honor, the state leaves it at your discretion.
On 2019 CF 11619, it will be a bond of $500. On case number 2019 CF 6666, that case is also a revocation in Division 14, and I set a bond now of $1,000 on count 1 and $100 on count 2. So the total bond is $1,600 on these 2 prior cases, and on the new case, you have a bond of $500. So the total amount you will have to post to secure your release is $2,100. You can apply to the judge assigned to each case for a reduction, but I find that that's appropriate in view of the fact that you had a case in the summer and did not have to post bond to get out, and then one earlier this month, and then a new one from yesterday. So you do have bonds now on each case, and you have the public defender on each case.
So how much is the bond on 50%?
I also order that you not go back to that location where the trespass occurred from yesterday. You'll need to stay somewhere else.
Thank you, Your Honor.
Robert Gunn. This is a misdemeanor charge of petty theft from yesterday. What? Mental health? All right, I'll reschedule Robert Gunn for tomorrow on the petty theft charge. Colby Lewis,
Yes, sir.
or is it Louis?
Lewis.
Lewis. This is a new charge from yesterday at 7355 Silver Star Road. The charge is battery. It's a first-degree misdemeanor. It has a bond of $500. It's alleged to have occurred at a 7-Eleven or nearby and involves alcohol. You have a prior case, possession of a controlled substance, so I'll have to take action on that. I appoint the public defender on the new case of battery. It's a bond of $500 on the new charge, no return to that 7-Eleven while the case is pending, and no contact with the person that is named as the victim in that case. On the prior case, I find that I am to take action today concerning that prior case. The charges on the prior case are felonies in Division 14, possession of a controlled substance and driving while license suspended. The case is 2019 It's CF 1683 AL, all right. The case is one in which I do revoke your release, and you have a new bond on those charges. The possession of a controlled substance, you now have a bond of $2,000, and on the charge of driving while license suspended, you have a bond of $100 for a total of $2,100 in the prior case, and a bond of $500 on the new case. This is Vishal Prasad. It is a charge of possession of drug paraphernalia from yesterday at South Orange Blossom Trail and August Lane. It is a first-degree misdemeanor charge. The public defender is appointed to represent you. It is a traffic stop at that point in the vicinity of Sand Lake Road. As I said, the public defender's now representing you, and this is a case in which the state may make an offer at first appearance.
Honor, at this time, the state wishes to offer an adjudication of guilty with credit time served.
Okay, you'll want to talk with your attorney about that offer.
Your Honor, he'll enter a plea of no contest.
And there has been a discussion between attorney and client concerning the question of whether he's on probation or not. I just want to make sure he's not on probation.
No, he's not on probation, Your Honor.
What is your full legal name? You'll want to speak into that microphone. What's your full legal name?
Vishal Anand Prasad,
And what is your date of birth?
1172.
The charge that's before the court today is possession of drug paraphernalia, which is a misdemeanor charge. It's a first-degree misdemeanor. How do you plead to that charge?
No contest?
Did you have enough time to fully discuss your options with your attorney, the public defender?
Yes.
Are you satisfied with the services rendered
Yes.
to you? And did you read and understand your plea form?
Did I sign it? Yes.
Did you read it and understand it?
Yes.
It has about 12 paragraphs concerning your constitutional rights that you're giving up by entering this plea. I want to make sure you understand that you can have a trial if you feel that you
No,
should go to trial. And I want to make sure that no one has made you or forced you to enter this plea.
No.
Do you have any questions you want to ask me concerning the charge, the facts of the case, the plea that you're entering, or the proposed sentence?
No, sir.
Okay. I notice that you have a substantial history, but every single one of them seems to have a connection with substance or substance abuse, whether it be alcohol or other more difficult and serious substances. Do you feel that you would be able to, have you reached the point where you have decided it is now
It's a little
very
bit too
inconvenient
much.
for you because you seem to wind up down here all the time for things that you could avoid,
Yeah.
all right? So you need to make a decision pretty soon because I don't want to see you
Yeah.
get into a real permanent bind. You understand what I'm saying?
Okay,
I mean,
yes.
this is the kind of case where it's up to you, and only you can do something about it, even if it means going into a treatment program of some kind on your own,
Right.
okay? I accept the plea at this time. I find that you are alert and intelligent, you understand the nature of the charge and the consequences of entering this plea. I adjudicate you guilty of the misdemeanor of possession of drug paraphernalia. It is 2 days credit for 2 days served. You have court costs that you will pay within 90 days from today, and you will be released later on today.
Okay, thank you.
Next case is Eric Paul Turek. Are you Mr. Turek?
Doing okay, sir, thank you.
This
Be
is
better if I
a-
wasn't here.
This is a charge of trespassing, failure to leave a property upon order by the owner, so it's trespass after warning. But it's complicated by the fact that you were out on bond on a charge of trespass on property after warning from September.
Sir, again,
Don't say anything yet.
I was charged, bond for what?
Hold on, hold on. I'm appointing the public defender to represent you on this new charge of trespass after warning. And so rather than say anything to me, first I want you to talk with your attorney about these various matters that are going to come up at this hearing. Your attorney will tell you not to say anything unless your attorney advises you to say something. This is a kind of case where I may have to take action on the prior case or may not, and there may be an offer to resolve the case at first appearances. So we'll hear from the state next. Right now, it's a $500 bond.
Your Honor, may the state have a moment?
Yes.
Thank you.
Thank you, Your Honor. Edith Bush for the state. Your Honor, at this time, the state is not going to convey an offer. The state is going to ask the court on his out on bond or release matter to, I believe that might have been was that an ROR or bond?
It was a $500 bond back in September. And the new charge said again, which makes me, it makes me think it's possible that each of the two trespassing is the same Walmart, perhaps.
And Your Honor, the state would recommend that the court take no action on the out on bond and stay the bond.
Okay, I think that would be appropriate. The bond is $500 on the new case, and you posted a $500 bond on the September case. You now have two. You're going to need to talk with your attorney about how to avoid getting arrested before you can get the first case resolved. Now you want to make sure you don't get arrested on another one before both of these are resolved. And probably they can be resolved together at some point. The new case has not been assigned a division. The prior case is in Division 2, and I take no action on the prior case, meaning you simply post the new $500 bond to get out from yesterday, but I do order you not to go back to that Walmart, and you have, in effect, avoided what often happens, and that is sometimes in a case like this, you would have the bond revoked and a very large bond of $2,000 would be imposed, because sometimes many judges will find in a particular case that it's the same as if you missed a hearing, is if you get arrested on the same type of charge over and over again. But right now, it's simply the $500 bond on the new case. Okay, make sure you go to each and every hearing on both cases. And they're easy to mix up, so you need to keep track of which one you're going to court on and so on.
And Your Honor, may we have a no return?
Yes, no return to the Walmart, and I imagine that's what was the condition on the first case as well, but maybe not. But I'm ordering you not to go back to that Walmart at 1700 South Orange Blossom Trail.
Sorry? Say it again, sir?
You're not to go to that location while this case is pending.
You said
Stay away from that
1700.
Walmart.
You said 1700, something like that?
It says that it was 1700 South Orange Washington Trail, Walmart.
It was in a Apopka.
Okay. Yeah, it doesn't say that here, but I should have realized because it indicates the case number is 2019 MM 737AA, so that means it's Apopka. And it was the Apopka Police Department that arrested you, so you are correct. It's 1700 South Orange Washington Trail in Apopka that you're not to return to on this case.
Hold on, let me ask you, we're talking.
We are done. I'm just waiting.
The next case I have, I don't have the person here, and the name is Amethyst.
She refused, Your Honor.
Okay. This is what I'm going to do on this case. It's a second time, and it's a felony assignation charge due to prior convictions. I will appoint a public defender to represent her in Division 15, and I will continue to set her, but that'll give an opportunity perhaps that she can be advised why it would be valuable to her to come to first appearances. But I'm not of the mind of forcibly bringing somebody in for a first appearance, because I've already found that I am making on the record that I have found probable cause to hold her on the felony. Her bond's $2,500, and I've already appointed the public defender, so there is literally nothing else that has to be done, but she may decide she would like to see. She's not being held on something else, or is she?
She just has a hold for reporting requirements, but we could just put it on the record even.
All right, I'll remove those. But reset for tomorrow anyway. John Gray?
Sir.
This is an arrest affidavit from Saturday, November the 16th, at Anderson and Albany. Count 1 is possession of meth, $1,000, it's a felony. Count 2 is resisting without violence, a misdemeanor, $100 bond. And count 3, assault on a law enforcement officer, which, okay, assault is a $100 bond. Total is $1,200 bond. The public defender is appointed to represent you. It is in the division that is EAB, and that would be what number?
16.
Division 16. $1,200 bond. Judge Elaine Barber.
Jeanette Howe also refused, Your Honor.
All right. Based upon the number of times refused, I will simply indicate that I have found probable cause to hold her on a $500 bond. And a no return to within 1,000 feet of the intersection of Nashville and 18th, which is it's probably in the vicinity of Grand Street. Charge, assignation to commit prostitution, $500 bond.
And Your Honor, the public defender was previously appointed, or?
There's no indication here of the public defender at any point. She simply refused, but I believe she's out on bond on a trespassing charge. So that's holding her right now on a no bond until she sees the judge. So therefore, I'm going to appoint the public defender now on the new charge. So that you can talk with her and point out to her she can't get out till she comes and sees me on this, because it's very likely that she may be able to get out. But she's held on that prior case, on case number 2019 MM 84225AO, the charge of trespassing in Division 83, and she's being held right now on that until she sees me. So I'll reschedule it for tomorrow, and we'll see if we can convince her to, it's in her own best interest to come see the judge tomorrow. So she's held, she continues to be held till she comes to court. Anthony Sarter.
Yes, sir.
All right, this is a warrant. And it is marked November the 1st, but it refers to an incident on October the 6th of 2019. Count 1, dealing in stolen property. Count 2, Florida Pawnbroking Act. Count 3, petty theft with 2 priors, which is a felony charge. The bond set by the judge that signed this on October the 31st placed a bond of $2,500 on count 1, $250 on count 2, and $250 on count 3 for a total of $3,000. And when a judge sets bond in that way, I leave it at that. That judge intended the total bond be $3,000. And I can see that most judges would have done it in a different order and might have used different amounts, but that judge clearly, that amount should not be interfered with. You can apply for a change in that or a reduction in that by applying to the judge assigned to the case. The case is in Division 14. Judge Tom Young is the judge. The next matter is case number 2019 CF 15889, driving while licensed revoked as a habitual traffic offender. Bond set at $2,500. So it's a felony revocation charge. That comes from 4112 Crab Apple Lane from Saturday the 16th. So your total bond, it seems to me, is $5,500 between those cases. The next matter is 2019 CF 15890. Count 1, grand theft, third degree of a motor vehicle. Count 2, resisting without violence. Bond is $1,100 for a total of $1,100. Assigned to Judge Jordan, John Jordan, in Division 19. The public defender is appointed to represent you in all these matters. And your total bond, I believe, comes to $6,600 if you add in all the various charges, $6,600 total on three different case numbers, under three different case numbers. One is a warrant and two are on view arrests. Dennis Herbert Tyner.
Yes, sir. I'm Dennis Tyner.
Thank you. This is a charge of soliciting without a permit, and it comes from Friday, November the 15th, at North Dean Road and University Boulevard. It's a county ordinance violation. The bond's $500, and I've appointed the public defender to represent you on that charge. And the issue before me next is whether the state attorney's office on behalf of Orange County is in a position to make an offer to resolve the case at first appearances.
Yes, Your Honor. The state's offer would be an adjudication of guilt, 5 days, Orange County Jail. I believe he has 4 days credit time served.
Let's
And
see,
court
yes,
costs.
it comes from the 15th, so it's 15, 16, 17, 18. It would be 5 days credit for 4, and I believe that using jail math that you get out this afternoon.
You on?
So, well, I want you to talk with your attorney about what's best for you.
And Your Honor, may the state have the last 4 numbers in the case number, please?
The case number 1143.
Thank you.
The month and year of my birth.
Your Honor, he'll enter a plea of no contest.
Mr. Tyner, can you read and write?
Yes, sir. I have a little trouble seeing.
Were you able to look at the plea form that you just signed?
Yes, sir.
Okay. What is your full legal name?
My full name is Dennis Herbert Tyner Jr.
Thank you. They've got your full legal name here as Dennis Herbert Tyner II.
Yeah,
Would
Jr.
would that be, well, they're not the same.
I don't understand that.
Okay, here's what happens. Let's say you have a grandfather and his name is Dennis Herbert Tyner, and his grandson has exactly the same name. That would not be a junior, that would be a second. only a father and son ordinarily has a senior and a junior, then the next person is the second, the next person's the third, and they're called Trey, and there's a whole bunch of stuff that goes on.
My daddy's name was the same thing as mine, but
Okay.
his was senior.
Okay. On your birth certificate, do you think it said junior?
It do.
Okay.
I have it.
Then we'll just indicate that you also have that name of Dennis Herbert Tyner Jr. So that would let people know that that's the same person, and they wouldn't be trying to differentiate you from somebody else. Like it would be more likely your son would have the name that's here, Dennis Herbert Tyner II. Anyway, it doesn't really matter other than, my job is to make sure the right person is here too. So sometimes I'll see somebody with the same name in front of me, but it says that they were born in 1980, they were born in 1999. I can see that would not be you, see? See what I mean? I want to make sure you're the right person, okay?
All right.
How do you plead to the charge?
No content.
And you did read and sign the plea form.
Yes, sir.
Are you satisfied with your attorney?
Yes, sir. She was real nice.
Okay. And you understand why you got arrested? Because I want to make sure you don't keep on coming back over and over again for something that's really, you're costing the people a lot of money by actually having to put you in a patrol car and bring you down here, and you go all through this, when actually you could do this legally in a different way. That's what I'm getting at.
Well,
You can't
Your Honor, I
st-
wish
you
you
ca-
just
you
tell
ca-
me that.
You can't stand at an intersection, and the reason is, one of the reasons is, some people can't tell whether you're asking money or demanding money. And secondly, we have plenty of people that get run over walking around cars at busy intersections, and so it's partially to protect you as well. All right? I accept the plea at this time. It's adjudication 5 days, credit for 4. I order you not to return to that intersection of North Dean Road and University Boulevard. That's a very large and difficult intersection. I'm just saying. I'm telling you not to go back to that intersection during the next 177 days, and the next 170 days. Court costs will go into a judgment. I don't think you're able to pay them right away, so it'll go into a civil judgment. Court costs. You'll be released later on today. 5 days, credit for 4.
Good afternoon, Your Honor. The Spanish interpreter is available at your earliest convenience.
Thank you. We'll be doing, we will begin those in just a moment. I have one case that'll go before the interpreter cases. This is
Yes.
Randy Battaglio.
Yes, sir.
It has been determined that you qualify for the public defender, and so I will be appointing the public defender to represent you with regard to the charges that come from yesterday at 5820 Edgewater Drive. The first count was resisting an officer without violence. That is a first-degree misdemeanor. And the second count is petty theft, a second-degree misdemeanor. The bonds are $500 and $250 for a total of $750. The case is complicated by the fact that it's indicated here that you have been released on a charge of trespassing.
There was actually a notice to appear, Judge.
That's a notice? All right. No action then is taken on that prior case, and we can proceed with the first appearance. And the next question would be, since I've appointed the public defender and I've advised Mr. Battaglio of his charges, is this a type of matter that the state may have an offer at first appearances?
Elaine Fusco for the State Attorney's Office, and we don't have an offer at this time.
All right. Your situation then, Mr. Battaglio, is that you can now bond out. I will have an additional condition after you bond out, is that you're not to return to the Wawa station at 5820 Edgewater Drive while this case is pending. Make sure you do not go within 500 feet of that location. All right. And stay in touch with your attorney so that you know when to go to court next, if you find out. All right. We'll now begin the interpreter cases. And the interpreter has been sworn.
Your Honor, for the record, Rafael Barrera, State Certified Court Interpreter, previously sworn.
Thank you. I'm Judge Kirkland, and I'm presiding this afternoon and appearing on behalf of the State Attorney's Office.
Elaine Fusco.
Thank you. And for the Public Defender?
Letitia Fowler.
All right. The first case that will be heard from this group is, I believe this is Mr. Gonzalez Mendoza. Is that correct?
See.
All right.
Yes.
All right, very good. This is a case that it is indicated the charge comes from a Florida Uniform Traffic citation. The charge is driving while under the influence. It is now an arrest affidavit from yesterday. The arrest took place at South Orange Blossom Trail and 35th Street. That is right where the Interstate 4 goes across, in the vicinity of where it goes across Orange Blossom Trail. The case number is now 19 CT 8377AO. You do not qualify for the public defender at this time. That means that based upon your application, the clerk's office, based upon the guidelines that the state uses, it is indicated that you do not qualify. You may qualify later on if you contest this case and you attempt to hire a private attorney and you're unsuccessful. Make sure that you keep the facts concerning your attempts to hire an attorney so that you can request a public defender later on. If the case goes to trial, the trial judge may, in fact, appoint the public defender if that judge finds that as a practical matter, you are not able to hire a private attorney, even though you may not qualify by using dollars and cents. Right now, your bond on this case is $500. It is complicated by the following. On February the 4th of 2018, it indicates that you were arrested on the charge of driving while under the influence and bonded out the following day. Case number 2018 CT, it's either 957 or 857, it's hard to tell. 957 on a $500 bond. I believe the following is to be done by me at first appearances when this happens. I believe that I am to revoke the bond on that prior case and set a new bond. The new bond is the same level bond that would have occurred had you missed a hearing. It is alleged that you committed the same crime again, and so the bond on that prior case is now $2,000, and the bond on the new case is $500. So your total bond for the two charges now will add up to $2,500, $2,500, in order for you to secure your release. And you're still facing both charges. Your attorney in that prior case is shown to be Corey Cohen. And you will need to stay in touch with your attorneys to be sure that you know when to go to court on each of the two cases. And it's quite easy to mix up court dates when you have two different cases, but each one having the same type of charge. The next case that I have is Alexander Rivera Nader.
Yeah.
This is case number 2019 CF 14169AO. It is a charge of resisting an officer without violence, a first-degree misdemeanor. And that was the original case number. It has now been transferred to case number 2019 MM 9168, which is a county court case number. And it indicates here that Mr. Rivera Nader has been in jail for 41 days. It does not show his representation. So the question is he represented by the public defender? All right, you are represented by the public defender, and so this is an arraignment. The question that would arise at this point is there an opportunity for resolving this case at arraignment?
Your Honor, there was an offer of adjudication of guilt, 40 days, credit time served, 180 days of supervised probation with 30 hours of community service and court cost. But my client would like to enter a plea of not guilty.
All right. This case then will be set in a county court division and will be set for a pretrial and trial. And we'll announce
My
that.
apologies, Your Honor. The interpreter's having difficulty hearing, Your Honor.
All right. I'll get closer to the microphone.
Thank you, Your Honor.
We will assign this case to a particular division in county court, Orange County, and we will set the pretrial and trial date for this charge of resisting an officer without violence.
Division 81, pretrial conference, December 13th at 9 a.m., courtroom 9C.
Courtroom 9C. That Judge McGinnis? All right. The next case is State of Florida against Ariel Ordonez.
My apologies, Your Honor. Can the interpreter have a spelling of that last name, please?
Ordonez.
Thank you, Your Honor.
Yes. This case number is 19 CF 15951-0. It is assigned to Division 16. The first count is child abuse. The second count is domestic violence battery. The first charge is a felony. The second charge is a misdemeanor. They both come to me today as no bond, but I will be setting the conditions of release today. The arrest is indicated to be...
Could you repeat the case number? I'm sorry, could you repeat the case number?
Yes, the case number is 19 CF 15951-0. The arrest is said to be by the Orlando Police Department at 5752 Shenandoah Way, Apartment A in Orlando, yesterday, November the 17th. The state can be heard at this time as to whether the state is asking for any special conditions of release considering these two charges and the history for Mr. Ordonez.
request no contact with the victim, no contact with minor children.
All right. Was either the state or the defense expecting to have a witness come today? Or we're not waiting for a witness?
Not that I know of, Your Honor.
All right. At this time, then, I find that based upon the allegations and the narrative of the charge of the arrest affidavit, as well as the history for the defendant, the appropriate conditions of release are, as far as the bond, the bond for count 1 is set by me today at $3,500. The bond on count 2 is a bond of $100 for a total of $3,600. I order that you will have no contact whatsoever with anyone that is named or referred to in the narrative as either a victim or a witness, including the officers. I do not have an ability to order where you will reside, but I am obligated to order that you will not reside at the same location as the victim. And so if the victim is located while this case is pending at 5752 Shenandoah Way, Apartment A, you will have to reside elsewhere. And therefore, you would be allowed to go one time with an Orlando police officer to get your clothing, personal effects, automobile, tools, whatever's there that's yours. It would be fair for you to be able to move those to where you are going to reside. But under our requirements, it is not possible for you to have contact or reside at the same location as the victim, which is a very young child in this case. While the case is pending, you are not to have possession of any weapons, including a firearm. Now, I do not have an application from Mr. Ordonez for an attorney. Are you planning to hire a private attorney, or if you cannot afford your own attorney, are you requesting the public defender to represent you on these charges?
Yes, that's fine.
Are you requesting the public defender?
Yes.
All right. We will give you a form that is called an application for criminal indigent status. And you will fill that out, and it will indicate what you own and what you owe and what you earn to see if you qualify for the public defender. I will ask you some questions in this hearing concerning that. At the time of your arrest, were you employed? Did you have a job?
Yes.
Where do you work?
Trabajo así con un contratista.
I work with a contractor.
All right. And are you paid by the hour, hourly?
Por día.
They pay me every day.
All right. How much are you paid a day?
Aproximadamente 130, 140.
Approximately 130, 140.
And how many days per week do you ordinarily work for the contractor?
De 4 a 5.
4 to 5.
Okay. Most weeks, do you work 5 days a week? Is that Monday through Friday? Usually.
Sí, 4 veces por mes. 4 días. 4 días, lo máximo así, toda la semana, 5, 4 días.
It's mostly 4, at the most 5 every week.
And what is the name of the contractor?
Él es, solo lo conozco por haber.
I just know him as Abel. Abel.
Does that employer pay you with a paycheck, or are you paid in cash?
He pays me in cash.
Okay. So that would be $600 per week. Does he qualify? Does not qualify. Do you support anyone other than yourself?
I just have my child here, my baby.
All right. At the present time, I'm advised that you do not qualify for the public defender, but you may qualify if you are unsuccessful in hiring a private attorney. And so, okay. Out of an abundance of caution, I will appoint the public defender to represent you at this time. The public defender is not allowed to represent someone that does not qualify, and so after the affidavit has actually been completed and reviewed, we'll find out ultimately whether you do have the public defender. But I will appoint the public defender today because I'm advised that it appears that you do qualify at the rate you earn your income and based upon the child, that you are the person responsible for the welfare of that child, even though you will not have any contact with that child while the case is pending. So the public defender represents you in Division 16, and you will sign a no contact order. It has 10 examples of what contact means. So it's very important that you know not to do anything that appears to the judge assigned to this case, the judge in Division 16. You want to make sure that judge does not believe you have tried to have contact. Because if you do, you go back in jail on an no-bond status and you'll be stuck here in the jail. So if you have any questions about what is contact and what isn't contact, you need to ask your public defender and allow your attorney to contact the court to straighten out any practical problems. All right?
Yes.
He also has an ICE detainer, immigration.
Okay. And so there's a further complication that your public defender will look into, and that is there's an ICE detainer, immigration hold. Okay, on here. Which of these matches up? William Rivera Bernard. This is case number 2019 CF 15933. I have appointed the public defender to represent you, Mr. Rivera Bernard, in Division 11. And that is Judge Denise Beamer, Division 11. There are 2 charges listed here. The first is a felony battery by strangulation, domestic in nature, and count 2 is a misdemeanor battery, domestic in nature. Those both are listed as no bond, but I will be setting the conditions of release today. These charges come from yesterday at 1920 Honor Road, number 4. The state may be heard concerning requests for conditions of release. There's a witness who will be sworn at this time.
Raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God? You need an interpreter?
Yes.
I will have the interpreter interpret for the witness and for the court audibly in the courtroom.
Certainly, Your Honor.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
¿Usted jura decir la verdad, toda la verdad y solamente la verdad ante Dios?
Sí.
Yes.
Please state your name for the record.
Dígame su nombre para que consten las actas.
Sandra Cabreras Torres.
Sandra Cabreras Torres.
Thank you. Does the defense wish to question this witness at this time?
No, Your Honor.
La defensa quiere hacerle preguntas al testigo en este momento, no, su señoría.
Does the state wish to question this witness at this time?
La fiscalía quiere hacerle preguntas al testigo en este momento.
¿Qué dice?
And you will
What are they saying?
you will have to speak rather loudly, I think, for him to hear you.
Okay.
Tienen que hablar en voz alta para que se le pueda escuchar.
What is your relationship to Mr. Rivera Bernard?
¿Qué relación tiene usted con el caballero Rivera Bernard?
Somos pareja, teníamos año y medio.
We're partners. We've been together for a year and a half.
That's all at this time.
All right. Do you have any questions now for this witness?
No, Your Honor.
All right. So this witness has completed her testimony?
Okay. So, we would like to ask for, no contact, separate residences, no weapons or firearms.
And do you feel that you know whether that is what this witness is requesting, or is it notwithstanding whatever her?
Notwithstanding, Your Honor.
You can return to the audience at this time. Thank you.
Señora, puede regresar al público.
Okay, thank you.
Okay. If you'll repeat the state's request at this time.
Yes, that was, Your Honor, that was no contact, separate residences, no weapons or firearms.
Based upon the first charge, I believe that would be what actually is required for first appearance judge. The issue that is more difficult would be the amount of bond. Is the state asking for a particular amount of bond on a felony domestic case? There is no such thing as a standard bond on a domestic case, I believe, but it appears to me to be one that would have a bond of $3,500 on count one with a bond of $100 on count two, based upon the allegations contained in the narrative and based upon no history in the past. So your total bond that you will post at this time is $3,600. You'll have no contact, and you'll maintain a separate residence from anyone that's named in the narrative, particularly the victim, Sandra Cabrera Torres, as well as her sister. No weapons, including a firearm. If my order causes you to move, and I do not rule who lives where, but if you are moving, you can return there one time with a sheriff's deputy to get clothing, personal effects, tools, motor vehicle, anything that's yours that can be established it's yours and you would need it. From a practical standpoint, you can go one time with a deputy to secure that property so that you can abide by the conditions of release. It's very easy to violate that. For that reason, there is a no contact order, and the order gives about 10 examples of what contact means. So you cannot call, text message, email, write letters, You cannot have someone else on your behalf try to make contact. You cannot send candy or flowers. There's just, all of those are covered by this order. So familiarize yourself with this order and make sure you understand what that means. And so if you have a question of any kind concerning contact, ask your attorney and allow your attorney to contact the court and the other attorneys involved in the case to solve practical problems. I understand there's always practical problems, but if the judge in Division 11, Judge Beamer, believes that you have violated that order, that judge would put you in jail on a no bond status. What was your question? Okay.
No.
All right. It is $3,500 on count 1 and $100 on count 2. That concludes the Spanish. That concludes the Spanish interpreter cases.
Thank you, Your Honor. Have a pleasant afternoon.
Thank you. You too? We have a Creole, so a person that has requested a Creole interpreter. Do we have a Creole interpreter online now? May I have to call him?
Did you have Mr. Flores Torres or Gomez Hernandez? Both gone? Okay.
You gonna do him now? You gonna do him now? The Creole? He's just here for ICE detainer. He's just here for ICE detainer.
His case already heard. His case was heard yesterday, he just needs to hold about his immigration hold.
But does he need a Creole interpreter?
Yeah.
So we're, he's already had his first appearance, but I am required to inform him of the detainer from ICE.
CF 015893 AO 893 AO.
Should we put this case number on?
Is the interpreter online?
Good afternoon, Your Honor. The interpreter is online, Creole.
Thank you. And you have already been sworn?
No, not yet.
All right. You will be sworn at this time?
Do you swear-
Certainly, Your Honor.
Do you swear to interpret from Creole to English and English to Creole the testimony you will receive today?
I do. Alex Moyes, certified court interpreter.
Thank you. This is
Thank you.
This is courtroom 1 at the BRC. It is Monday, November the 18th, 2019, and I'm Judge Kirkland reviewing the case of Yves, that's Y-V-E-S, or Yves, Kendi Laguerre, case number 19 CF 15893. He has already been seen previously for a first appearance. He is here before me today to be informed that there is an ICE detainer, that is an immigration hold, that holds him for the period of time that is allowed by law, and so that he and his attorney are now aware that that is a further complication of his case. All right? And so if you have any questions concerning that, you would want to ask your public defender about that. And that is the hearing for today.
Thank you, Your Honor.
Would that be it for the interpreter, Your Honor?
Yes, thank you very much.
Thank you, Your Honor.
The other interpreter. This is Cross Charles Caputo.
Yes.
There is an arrest affidavit from yesterday. An arrest that took place at South Kirkman Road and Conroy Road by the Orlando Police Department. There are 4 charges.
I'm sorry, could we repeat the name of the defendant?
His name is Cross, C-R-O-S-S, Charles Caputo, C-A-P-U-T-O.
Okay, thank you.
Count 1 is possession of cannabis, more than 20 grams, bond $1,000. Count 2, possession of meth, bond $150, felony. Count 3, possession of cocaine, felony, bond $150. Count 4, possession of cannabis with intent to sell or deliver, which is a felony, bond $150. So your total bond is $1,450. The case begins at the 7-Eleven gas station in the vicinity of Kirkman and Conroy. The narrative is 2 pages long. There is a second matter. It is an on-view arrest affidavit for violation of probation for out of county. That county is Osceola County, which is a part of the 9th Judicial Circuit. So you are being held on a no bond status on a violation of probation, case number 1803079. The scheduled termination date of that supervision in Osceola County was August the 25th of 2020, so there is jurisdiction to hold you until you see the judge in Osceola County on that case, which involves 2 charges. The sentence was on February the 26th of 2019 in Osceola County for possession of cocaine and possession of drug paraphernalia misdemeanor. The sentence being 18 months of supervision on the first charge and 11 months and 30 days on the second charge. The case is being 1803079. That being a no bond status until you see that judge. Do you have an attorney?
Yes.
A private attorney?
Yes.
All right. So you want to contact your attorney to perhaps address the Osceola County case first, because that's what's keeping you in jail. If you bond out on the 4 Orange County cases, you'll be transported to Osceola County as a matter of course. But that's something you can talk to your attorney about, what your attorney wants you to do with regard to the 5 matters that are before the court today.
Valerie Dalby is mental health nurse.
All right. Her case is grand theft, 3rd degree of a motor vehicle, and has a $1,000 bond, so I'll reschedule her for tomorrow, and we'll see what happens in the meantime. There is probable cause to hold her on $1,000. Terrell Levy. Are you Mr. Levy?
Yes, sir.
Thank you. All right, this is an arrest affidavit from yesterday. The arrest took place at Woods and 31st Street. That's right around Cayley and a block away from South Trail. The charge, possession of cocaine, bond $1,000. The next matter is an arrest affidavit for violation of probation because of the first charge. And that case number appears to be 19 CF 2621 AO, assigned to Division 22. I'll appoint the public defender to represent you in Division 19 on the possession of cocaine charge and on the violation of probation in Division 22. In reviewing this on view, violation of probation under 948.061C. It is a scheduled termination date of April the 17th of 2020, so there is jurisdiction. That was a sentence in Orange County on February the 21st of 2019. I'm sorry, the sentence date was April the 18th of 2019 for 1 year of probation, supervision, case number 192621. No bond. The public defender represents you on both matters. And you're held on a no bond status on the violation of probation until you see the judge assigned to that violation of probation. The next matter is an affidavit that arose out of the Florida Uniform Traffic Citation. Those are driving charges. One is reckless driving, $500 bond. Second is driving while license suspended, $100 bond. Total $600 on those 2. And there's a case number for each of the 2 misdemeanors. The first, reckless driving, is 19 CT 8383 AO. The driving while license suspended charge is 19 CT 8384 AO. So those are consecutive case numbers in county court. There's a condition of release on the second count. The driving while license is suspended. That condition is not to drive until your license is reinstated while the case is pending. Next case is State of Florida against Chiles Parker.
Yes, sir.
This, is an arrest affidavit from earlier today, 3:28 this morning, at 321 Lime Avenue. The first count is attempted first-degree murder with a firearm, which has a no bond status. It is a life felony or a possible life felony, and it is one in which there's probable cause to hold you, and you can talk to your attorney, which is who is the public defender. I appoint the public defender to represent you in Division 22. The second charge is possession of a firearm by a convicted felon, and it has a bond of $150 because the first count is a no bond status. While you are being held in jail, and if you do ultimately receive conditions of release, you would have these conditions: no contact with anyone that's named in the narrative as a victim or a witness or an arresting officer or an investigator or an attorney involved in the case on the state's side of the case. Talk with your attorney about particularly count 1, in which you can request that a motion to set bond be set in front of the judge, in Division 22, in which the state would have to convince the judge that the proof is evident, the presumption is great. There's a complication in the case as follows. It is indicated that you were out on bond on case number 2019 CT 7423 AO, Division 82. And that arrest was October the 8th, and a bond was posted on the same date with a return date of December the 12th. And the following is what is appropriate in this case. I am to revoke the bond in that case, and you are to receive a new bond on that case that would be applicable. You would obviously, from a practical standpoint, would only do that if you receive conditions of release on the other case. But your new bond on that charge is appropriately set by me to be $2,000 now on the driving while license suspended with knowledge case 2019 CT 7423 AO. I also now appoint the public defender on that prior case. He did not have an attorney. He now has a public defender since he's qualified for the public defender on the new charges. I think there's one other condition I have to set on the new charges. I believe there's a co-defendant. I'm not certain of that, but assuming there's a co-defendant, there's a condition of no contact with the co-defendant. The next case is Tashiona Smith. There are two affidavits before me. The first affidavit is case number 2018 CF 5823, failure to appear. It's a capias. That means to me that an information has been filed in the case, charging you with possession of cocaine and possession of drug paraphernalia. And this is a failure to appear for a status hearing on November the 8th of 2019. Defendant is to be brought in front of a judge within the next day of arrest, revoke release. No bond. So you're to appear as soon as they can get you there to see the judge in Division 20, and that's no bond till that occurs. The second warrant arrest affidavit is for the same two type of charges, but a different case number. It's also in Division 20, also no bond, fair to appear for a status hearing, same date. So these two cases are together with two different case numbers, both being failures to appear, and each one having count 1, possession of cocaine, count 2, possession of paraphernalia. You have a number of other cases that are shown here, and so it appears to me that there are perhaps 6 holes because of the other cases. And I am indicating that I take no action on those prior cases. They are no longer holding her. It is the 2 affidavits that I have before me from Division 20 that holds her, and she will have to see the judge in Division 20 for that judge to decide in view of everything, whether she will be held without bond until the case is resolved, or whether she will have new conditions of release. The next case is Alfonso Taylor. The first affidavit that I have, there are 2 different affidavits. The first one I have is possession of a firearm by a convicted delinquent. The bond has been set at $5,000. The public defender is appointed to represent you in Division 12, and the case number is 18 CF 10630 AO. I'm sorry, that is the wrong case number. The case number for possession of a firearm by a convicted felon from earlier today, the arrest taking place at Columbia and Ivy Lane, that case number is 19 CF 15955. 15955 AO. The case number, and that's in Division 11. The case number of 18 CF 10630 is a violation of probation on view, and it's assigned to Division 12. Because of the new charge, it is indicated that you will now have to face a violation of probation, and that is for a sentence that was imposed on May the 3rd of 2019 here in Orange County for 2 years of supervision for trafficking in MDMA. Termination date, May the 2nd of 2021, so I find jurisdiction. And the public defender represents you in Division 11 and Division 12. There's one other complication in the case. And that is, Alfonso Taylor was out on bond, a $1,000 bond in case number 2019 CF 11941. Attempted burglary of a conveyance, Division 14. Arrest was August the 22nd of 2019, bonded out on September the 13th of 2019. I find that due to the new matters, I am to take the following action. I revoke the bond in 2019 CF 11941 AO, and you are held without bond until you see the judge in Division 14. Your attorney in that case is Fabian Goffey. I don't know if that's a public defender or a private attorney, but in any event, there is an attorney in that case, and that judge will have the file and will have an opportunity to look at all of the matters and decide whether you should be held without bond until the attempted burglary of a conveyance is resolved, or whether you should have a new set of conditions. But right now, I am required to make it no bond on that case. The next case is Lonnie Joe Tomlin. This is an arrest affidavit from earlier this morning, a little after midnight, at 5265 South John Young Parkway. That's a Publix store parking lot. I've reviewed the narrative. First of all, I appoint the public defender to represent Mr. Tomlin. I've reviewed the narrative, and I find probable cause to hold him on count 1, aggravated assault with a deadly weapon, bond $2,500. I find that based upon the allegations contained in the narrative, that there is one count of resisting with violence, so it would have a bond of 150, and there is evidence of one count of resisting without violence, having a bond of $100. So to correspond to what has been outlined here, the officer seeks to have 4 counts of felonies resisting with violence, but there are no facts to that would ever occur. There would be 4 different charges, and only one with violence, and the others would be without violence. So that's what the probable cause is today. The state, if the state is requesting, you can request a period of time to get additional facts, but that would be what I'm doing today. It would be $2,500 on count 1, $150 on count 2. Count 3 would have a bond of $100, and counts 4 and 5 would be ROR.
Your Honor, could we have 24 hours to contact law enforcement?
Yes.
And Your Honor,
Yes,
defense objects.
Since I have done that, you can request 24 hours to file an addendum or a witness statement, something that supplies the court with facts that are not present in this particular affidavit that would amount to more than one count of with violence, one count without violence. If Mr. Tomlin chooses to bond out in the meantime, it will be by him posting a bond of $2,750. I'll see him again tomorrow to see
Your
if
Honor,
there's.
could we object to the bond?
If he's giving us 24 hours, he can't let him bond out on the counts. We're asking him to not give the RO time to get between, it's a 24
We, for the 24 hours, we would like to continue to have the defendant held until we get the charges clarified if possible.
That's the whole point of the 24-hour reset.
He's going to be held because of what I'm going to next.
Okay.
And so I'm leaving that as it is. But the complication for Mr. Tomlin is as follows. He was out on bond at the time of the events that are the subject of the new cases. The prior case is case number 2019 MM 8453, assault on a person 65 years of age or older in Division 50. And at this time, I revoked the bond in that case, and he is held without bond till he sees the judge in Division 50. And so I stand on the bonds that I set. We'll have that solved before he has an opportunity to be released in the case because of the hold for the prior case.
So, Your Honor, his initial appearance will be reset for tomorrow?
Yes, yes. I've given the state 24 hours to provide additional information if they are able to do so. This is Keith Brown. This is a misdemeanor affidavit, possession of drug paraphernalia from South Orange Boston Trail and August Lane from yesterday. It is resulting out of a traffic stop.
Yes.
I appoint the public defender to represent you. Is this a case in which the state is making an offer to resolve the case at first appearance?
The state offers for adjudication of guilty, 5 days with the credit of time served, which I believe is 2 days, and then costs.
Mr. Brown, I want you to talk with your attorney. I'm appointing the public defender to represent you. You have the following option. Your choices would be to bond out on this case. Your bond is $500. Or if you decide it's in your best interest and your public defender agrees, the sentence on this case, if you enter a plea, would be 5 days credit for 2. Well, do we have Shanti Ginsing? So we're gonna try to get the interpreter on the line shortly.
Your Honor, you'll accept the plea offer, enter a plea of no contest.
All right, thank you. What's your full name?
Keith Anthony Brown,
And what is your date of birth?
March 15, 1966.
The charge that's before me is possession of drug paraphernalia from yesterday at Orange Boston Trail and August Lane. How do you plead to that charge?
Guilty.
Did you have an opportunity to read and understand your plea form?
Yeah.
Okay. Do you have any questions you want to ask me about this case? Are you satisfied with your attorney?
Yeah.
In other words, have you had enough time to discuss your options? Do you feel that you understand your choices?
Yeah, man.
They may not be good ones, but I just want to make sure that's why I'm asking you if you have any questions and make sure that you don't feel like that you're being hurried along or anything. Do you think this is the best thing for you to do?
Yeah, because I don't have the money to bond out or don't have nobody. I'm homeless and stuff, so.
Okay. But do you feel that no contest is the appropriate plea? No contest? It says you're not admitting anything, but you think out of convenience, the best thing for you to do is enter a plea to the charge. Okay. And I believe that 5 days credit for 2, ordinarily, you'll be out either Tuesday or Wednesday. Wednesday. I'll accept the plea at this time. You're adjudicated guilty of it's a first-degree misdemeanor, possession of drug paraphernalia. And it shows in your record this is your first Florida arrest. You may have some other matters when you were younger, out of state. But the appropriate conviction in this case is a conviction, 5 days credit for 2. Court costs, you'll have 360 days from today to pay the court costs. This is Shante Gizing. Okay. We have an interpreter that will come online. About now.
I'm gonna call back.
All right.
Judge, she says she understands English as long as you talk regular. That's what she just said.
We will do that only if we can't get the interpreter on. It's best to have the interpreter just in case. One thing that she could do is, if we could give her the form to fill out to request a public defender.
Okay.
We don't have one, so
The form up here?
I don't believe she's filled one out. Do we have those forms?
Some words I don't understand how to look the dictionary.
I think she speaks some English, so she might be able to fill that out.
I'll go for it.
The case she's here on is battery.
Reckless driving, duelist, and assault with a motor vehicle ×2.
Hello?
Yes, sir.
Would you state your name as the interpreter?
Sunita?
And you are interpreting live in the courtroom today for Shanti Gizing.
Thank you.
And her case number for your benefit is 2019 MM 9308.
Thank you. I'm ready.
All right. She is charged with battery, domestic violence battery.
नमस्कार म दोबासे हजुरलाई चाहिँ आरोप लागेको छ घरेलु हिंसा
It's from an arrest yesterday.
हिजो तपाईलाई गिरफ्तार गरिएको थियो
The person that is listed as the victim is Eric Roman.
एरिक रोमन चाहिँ पीडित व्यक्ति हो
And Eric Roman and Shanti Gizing are married.
एरिक रोमन र शान्ति घिसिङ विवाहित हुनुहुन्छ
I have found probable cause to hold her on the charge of domestic violence battery.
घरेलु हिंसाको कारणले गर्दाखेरि त्यो आरोप लागेको छ
I am going to ask her some questions to see if she qualifies for the public defender.
म केही प्रश्नहरू सोध्छु अनि हजुर सरकारी वकिल पाउन योग्य छ कि छैन बताउँछु
I understand that you are you have a job as in the health care at work at Encore at Avalon Park. What is your job?
Caregivers. As a caregivers,
And are you paid weekly or every 2 weeks?
every 2 weeks.
What would be the usual amount on your check, that on your paycheck, that is your take-home pay?
It's like 600.
All right. She clearly earns. She clearly understands quite a bit of English, but I wanted to have an interpreter here. If there's anything you don't understand fully, you can ask the interpreter to assist you.
Okay.
All right. Does she Do you support anyone other than yourself? Do you have other family?
No.
Okay. Does she qualify at $600 every 2 weeks? Okay, I appoint the public defender to represent Shanti Gizing. And at this time, I'm going to ask the state attorney, are you asking for any special conditions of release in this case?
Yes, we would like to have no contact, separate residences, no weapons or firearms.
All right. And that would be appropriate in this case. I've reviewed the facts that are shown in the affidavit, and there are a number of conflicts in the facts. I find that the appropriate conditions of release are as follows. It is a bond of $750, no contact with Eric Roman. I am not indicating who will live where, and this may need to be interpreted for her. You will receive a no contact order that tells you what you can do and can't do. And I'm not saying where you will live, but you must live at a different residence than your husband Eric Roman while the case is pending.
यो मुद्दा पेन्डिङ हुँदा समेत नि हैन हजुरहरूले सम्पर्क राख्नु भएन कि को कहाँ बस्नुहुन्छ भन्ने कुराहरू चाहिँ मैले बताउन सक्दिनँ तर हजुरहरू चाहिँ छुट्टै बस्नु पर्यो एरिक रोमनसँग बस्नु भएन.
That order can only be changed if Eric Roman appears in person in front of the judge assigned to the case and testifies that he wants to have contact, and if the judge decides that that's appropriate after hearing that. I am not allowed to make a decision other than what I've just made unless there's unless he appears in front of me and testifies that he is seeking to have contact. So this may be temporary, or it may be the conditions until the case is ended.
Will the court consider giving her PTR?
Does she qualify?
She does qualify, she will have to provide an alternate address to be released on dispatch.
Okay. And what is the state's position concerning that
We object.
request?
We object.
All right. I think that $750 would be appropriate for what I saw in the facts. She can go to that if she is moving, and I'm not saying who should live where, but if she is moving, she can go one time with the deputy to get her clothing and personal effects, or automobiles, anything else that happens to be there that's hers, if she's going to move somewhere else. But if you do move, you must advise your attorney of your new address, and it's important that your public defender be able to reach you and by telephone and to know what your address is. There's another condition of release, and that is you're not to be in possession of any weapons, including a firearm, while the case is pending.
हजुरलाई चाहिँ नि हैन 750 थरौटीमा छुट्ने हुन्छ हैन अनि हजुरले चाहिँ नि यदि त्यो ठाउँमा गएर को सर्ने हो अब तपाई सर्ने हो कि उहाँ हो उहाँले त्यो भन्नु भएको छैन तर जो सर्नु हुन्छ घरबाट तपाई सर्ने हो भने चाहिँ हजुरले चाहिँ प्रहरीहरु यहाँको प्रहरी प्रशासनको मान्छेलाई लिएर गएर चाहिँ हैन आफ्नो सामानहरु हजुरको गाडीहरु के छ कि त्यो लिनको लागि चाहिँ यहाँको मान्छेहरु जानुपर्ने हुन्छ हजुरसँग अनि तपाईले लिएर निस्किन सक्नुहुन्छ अनि यदि हजुरको नयाँ ठेगाना भयो भने एकदमै जरुरी कुरा हजुरले पब्लिक डिफेन्डरलाई हजुरको नयाँ ठेगाना हजुरको टेलिफोन हजुरको ठेगानाको जानकारीहरु दिनुपर्ने हुन्छ हात हतियारहरु त्यस्तो विस्फोटक पदार्थहरु के राख्नु मिल्दैन.
Because I believe that alcohol played a part in the events that caused you to be arrested, I am also going to add a condition that you're not to consume or be in possession of alcohol while the case is pending.
हजुर मलाई के विश्वास लाग्छ भने रक्सीको कारणले यो कुरा भएको हो र हजुर पक्राउमा परेको हुनाले म के सर्त थप्न चाहन्छु भने यो केस पेन्डिङमा हुनुजेलसम्म हजुरले चाहिँ नि रक्सीहरू मदिरा सेवन गर्नु भएन।
All right. Oh, we're finished. Thank you very much.
Thank you for using our services. You have a good day. Bye-bye.
You too. And that is our last case for today, I believe.